Good afternoon, everyone. My name is Ken Goldberg. I'm a professor in engineering here at Berkeley's campus. I'm also a professor in art practice and at UCSF. And it's a great pleasure to introduce today's speaker. This will be the fourth in a series of distinguished speakers on the status and future of AI that are presented by CITRIS, the Center for Information Technology in the Interest of Society, and the Berkeley AI Research Lab. So we've had a remarkable lineup of speakers this month, and we're glad to see all of you joining us in person here today and virtually on the live stream. We're planning our fall research exchange series that will start in September, so please stay tuned and check out the website at citris-uc.org. So we're also honored to be part of a larger series on AI here at Berkeley that's featuring 7 leaders and experts in the field, including the co-founder of ChatGPT, Berkeley alum John Schulman, who spoke last week. You can visit berkeley.edu/AI to learn more, and we will have one more speaker on Friday, that is Rod Brooks, who will be presenting Friday at noon. That's also accessible on the web. Not here. We'll be in a different location. Okay, so as far as our speaker, she has a very distinguished history. She studied history, political science, and law, and she graduated at Yale University. She has been writing and lecturing and pioneering both research and the law in terms of intellectual property, cyber law, and information privacy. She's written extensively on AI, authorship, and legality, the legality of data mining in terms of text, images, and other forms of data, which is what she's going to be addressing today. She's really been a pioneer for many years on the questions at this intersection of information technology and law. And we are grateful to her for being the founding director of the Berkeley Center for Law and Technology, which is now known around the world. And she has been a contributing editor of the communications of the ACM, which is the Computing Machinery Association. And I would also say she's one of the few lawyers that has been involved and is also a fellow of the ACM. She's also very, very wonderfully a MacArthur Genius Grant winner, and she has many other titles. She's also a board of directors of the Electronic Frontier Foundation and many other lauds to her credit. I want to say that she is Richard M. Sherman 74 Distinguished Professor of Law and Information here at Berkeley, and I have found her to be a wonderful colleague and friend over the years, and she has done so much to advance this field and Berkeley's reputation in it. So we're extremely grateful. So please welcome Pam Samuelson.
The tech people who are supposed to do their magic. All right, magic has started. Hi, so this is a very different kind of topic from the ones that preceded this, but I think that you'll find that it's more interesting than you probably thought when you got here. So the excitement is palpable all over the world these days about generative AI, so it's not just the people in the computing field who are excited about the incredible innovation that has been happening, but hundreds of millions of people out there are using ChatGPT and other generative systems. Companies all over the country are trying to sort of figure out what's our generative AI strategy here. One of my colleagues, one of my former students, who's a practicing lawyer downtown San Francisco, says that his practice right now is overwhelmingly advising companies about what to do about generative AI. So it's really causing quite a stir. Of course, there are some suggestions that ChatGPT or that GPT-4 exhibits sparks of artificial general intelligence. I think it's probably too early for that to be really true, but I was talking to Joey Gonzalez recently about some of his students building large language models too, so it's really spread all over the world. Now, one thing that will come as a surprise to some of you who are kind of really excited about all of this is that not the rest of the world is so excited or positive about generative AI. There's one lawsuit against GitHub, Microsoft, and OpenAI that's challenging the legality of Copilot, the software that suggests code in response to programmer prompts, and Codex is also said to be unlawful. It's the large language model built on millions of lines of open source code. There are two lawsuits in the United States against Stability AI for challenging the legality of Stable Diffusion. And in the Copilot case, the plaintiff's asking for $9 billion, which is a lot of money. And they're also asking for injunctions to shut these systems down. And the two principal claims that are being made is that the process of ingesting in copyright works from the internet or elsewhere is an infringement of the copyright in the works, and also that the outputs, whether they are source code, text, images, or music, are infringing derivative works. The U.S. Copyright Office is holding what they call listening sessions about what people think about this, and some of the people are saying, oh, it's fair use and no problem, and others are saying, oh, massive piracy and we got to shut this stuff down. So it's important to sort of understand that this is actually super controversial, at least in the legal community. And this particular drawing will give you an idea about sort of the perspective of some of the people in the arts field, because this is the stolen art that goes into the large language model, and guess what comes out the other side. So this is an example of a reaction to generative AI that I think is unfortunately shared more than you might expect. So there's a broader moral panic, of course, about AI. The Future of Life open letter that many of you have read calls for a 6-month pause in AI development. It talks about how important the profound risks to society and humanity are, and really says we need to plan, we need to have some policies in place, and right now we really don't. And so there's a kind of panic about it. This week, actually, there are meetings in Europe about about what to do about generative AI and about AI systems generally, and what kind of regulation should we have, and so forth. So there's really a lot of emphasis on law and policy in this space. And one of the comments that has been made about generative AI called it a Marxist nightmare, because millions of works of millions of writers are accruing to capitalist owners who pay nothing for all of that labor. So it's really really has got some people very upset. So nobody's going to the barricades yet, but this is actually an early stage. So I want to, in the time that I have, address 3 principal questions. So the first is whether making copies of works as training data for generative AI systems infringe copyright. When are AI-generated outputs infringing derivative works? And then who owns copyright in the outputs of computer programs that are copyright subject matter? Sort of who, if anybody, owns that copyright? Now, you may think that last question is really boring, but people have been arguing about that since the mid-1960s. So it's actually the oldest of the problems that AI presents in terms of copyright. So this is the outline for the rest of the talk. I have to give you at least a couple of minutes about copyright, because This is the shortest version I could think of. So important to sort of understand that copyright law protects works of authorship from the moment they are first fixed in a tangible medium, and that protection lasts for the life of the author plus 70 years, or if it's corporate authored, for 95 years from the first publication. The rights vest in authors. What do they get? They get these rights, exclusive rights to control reproductions, distributions of copy, making of derivative works, and public performances and display. And that means that every photograph that you take with your phone, every email that you draft, everything that you create that is an original work of authorship, copyright automatically attaches to it. So that even though there's lots and lots of stuff out there on the internet, you should not assume that it's not in copyright unless it's authored by the U.S. government, or it's CC 0 licensed, or was created before 1926. An important thing, though, here is that copyright only protects the original expression in works of authorship, not their ideas, facts, or methods. And copyright's exclusive rights are limited by fair use and some other doctrines. And fair use is relevant to the ingestion issue. I'll give you a quick rundown about that. So fair uses of copyrighted works in the U.S. are not considered to be infringements of copyright. It's a defense to charges of infringement. And courts consider 4 factors when deciding if a use is fair: purpose and character of the challenged use, criticism, comment, news, teaching, research, and scholarship are all kind of favored uses, as are non-commercial as compared with commercial. The nature of the copyrighted work, in general, artistic and fanciful works get a broader scope of protection from copyright and a narrower scope of fair use. Factual and functional works get broader fair use and narrower scope of protection. The amount and substantiality of the taking and the effect of the challenged use on the market for or the value of the work. So the courts basically try to balance those factors together. So is ingesting works as training data fair use or infringement? Well, there are a couple of cases that suggest that actually it might be fair use. So in a case called Field versus Google, a court held that a search engine, that is to say Google's copying of internet content for the purpose of indexing the contents, was fair use and not infringement. So it wasn't trying to exploit the works in ways that copyright law is concerned about. And another case that's important, and more important actually because of an appellate court decision, the Authors Guild v. Google decision was one in which the court held that Google's digitizing of millions of in-copyright books from research library collections for the purpose of indexing contents, serving up snippets in response to search queries, and doing making other computational uses of the works was fair use. And again, it was because they weren't exploiting the expression in the work. They were just giving you a little bit from time to time. And mostly it was in response to queries about facts. And again, facts are not protected. So Stability AI and other defendants in these cases claim that these cases support the idea that web crawling of the internet to make copies of that for training purposes is actually a fair use and not an infringement. But some of the people who object to training data ingestion distinguish the Authors Guild v. Google case because in those cases, in the Field and Authors Guild cases, Google was making it easier for people to find the copyright owner's works, whereas what's happening with Stability and others is they make new images that compete with the images that were copyrighted
as in the training data, and copyright owners didn't consent to it. They can't easily opt out, and they think that it's only fair that they should get compensated because the value of the material that's being ingested is what makes the generative AI turn out good stuff. And so the argument is pretty strong for them. Otherwise, the generative AI systems would produce garbage, right? Garbage in, garbage out. And so the carefully curated works of authorship are things that somebody should get paid for according to this this perspective. And the Authors Guild, which is one of the major authors societies, did a survey, and 90% of their authors think that AI developers should pay for ingesting their works into the as training data for a large language model. And there are also some licensing markets that are emerging, and that is particularly important because the fair use analysis considers, is there harm to the market? And if there's a licensing market for the training data, then that's arguably a harm to that particular market. Now, there are some countervailing considerations, so it's a little bit too early to say, oh, doom and gloom. But here are a couple of ways of thinking about that. So if copyright law only cares about protecting the original expression in a work, well, that should be a factor because the people who are ingesting the training data, the works as training data, don't think about them in terms of their sort of expression. They think about them more in terms of they're a bag of words, and words by themselves are not protected, facts by themselves are not protected, and so they're kind of raw material for computational uses. And text and data mining has been widely thought to be fair use, and so this is kind of like the text and data mining that has already been found to be fair use. And the generative AI systems enable the creation of new works, and the constitutional purpose of copyright is about promoting the progress of science, by which the founders meant knowledge, and useful arts. And certainly the generative AI systems can be said to advance that purpose. And fair use provides a little breathing room for new creation, and so that may also bear on whether the ingestion is fair use or not. The issue about the derivative work right is important here because a statute talks about what does it mean to say that an author has an exclusive right to prepare derivative works. Well, derivative work is defined as a work based upon one or more pre-existing works, and then it gives a set of 9 examples: translations, musical arrangements, motion picture version, and so forth, or any other form in which the work may be recast, transformed, or adapted. And some courts give a very broad interpretation to this last clause, and some courts give a very narrow interpretation. But courts have consistently, at least so far, held that for a second work to infringe a first work's derivative work right, the author must still have taken a substantially similar amount of original expression from the first work. Just being based on the pre-existing work is not enough. So for the most part, generative AI outputs, text, images, and the like, are not going to be substantially similar to the data that was ingested during the training data series. And if that's true, or insofar as that's true, outputs are unlikely to infringe that right. The complaint in the GitHub case reports that one study showed that Copilot yielded up as output some code matching training data in about 1% of the outputs. And I don't think that necessarily is going to be meaning that Copilot infringes. But one of the problems is that when many ingested works depict the same image, such as Mickey Mouse, the large language model may memorize that, and then the output, you ask for an output of Mickey Mouse, and it may look just like Mickey Mouse, in which case Disney might have a claim of infringement. So one of the things that people who are trying to avoid infringement are thinking about is ways to remove duplicates from the training data, so that's less likely, right? The more duplicates there are, the more likely memorization is to happen. And then others are looking to use output filters to prevent infringing derivatives from being produced. Of the two cases in the US against Stability AI, Getty is the strongest one. Getty claims that Stability ingested 12 million photographs from Getty images. And not only that, but the captions, right? One of the things that's very valuable about the Getty photographs is they all come with captions that basically describe what the content of the thing is. And so they're arguing that that's a copyright infringement, and there's another law that protects copyright management information, like Getty logos. Getty is also claiming a trademark infringement claim, and its complaint shows some stable diffusion outputs that Getty claims are infringing derivatives. And importantly, Getty is willing to license uses of images in its database as training data, but objects to Stability's massive infringement. So this is an example of an original Getty photo and then a stable diffusion output. Notice this, right? This is a kind of a, shall I say, a mangling of the Getty logo. And so that's actually something that doesn't bode well for this particular case. But again, these cases are in very early stages, and it's hard to know how long it's going to take to address all the issues. As I said before, the copyright lawyers have been debating who owns copyright, if anybody, in the outputs of computer-generated software. And there were actually a lot of things written in the 1980s, including something I wrote. And so I went back and read it again recently, and it was actually pretty good. So it was like, phew. Anyway, so that's the thing. It's available on the internet, of course. So if you're interested, so this is an image generated by a guy named Stephen Thaler. Stephen Thaler owns a computer, developed some software that is generative AI. This is one of the images that his generative AI system produced, and he took this to the Copyright Office and said, please issue us a registration certificate. Now, for the most part, people don't go to the Copyright Office to get a registration certificate unless they want to sue somebody for copyright infringement. But Stephen Thaler went to make a point, which is he thinks that he should be entitled to copyright. And what he says is that the Creativity Machine, that's the name of his software, is the author of it, but he's the owner of the copyright in the image because the software was like an employee of his, so he calls it a work for hire. And so, generally speaking, the original works that are created by employees in the scope of their employment is owned by the employer. And so he tried to get a copyright for that, and the Copyright Office said no. And he asked for reconsideration. They said no, lacks human authorship. And so that's actually, he wasn't satisfied with that, so he took them, the Register of Copyrights, sued her, asked the court for a declaration that in fact the register has to grant him this registration certificate, and that's pending in federal court in DC. I don't think he's going to win. this is Zarya of the Dawn. So Chris Castanova is somebody who uses Midjourney to create images, and this is part of a little book of images and text that Castanova created, took it to the Copyright Office. The Copyright Office issued a registration certificate, and then on social media, somebody from the Copyright Office found out that she said, "Oh, I got copyright in my AI-generated images," and the Copyright Office said, "Hey, wait a minute," and cancel that registration, and instead said that she could get copyright in the text and the selection and arrangement of the images, but all of the images were not protectable by U.S. copyright law, and so she got a changed registration. This led the Copyright Office to actually issue a policy statement about AI-generated works. They lack human authorship, and that, I think, means that the works are in the public domain and available for free copying, so you can't stop anybody else from using it if it's out there in the public. And Copyright Office also says that if you apply to register copyright in works that incorporate AI-generated text, images, or other content, you have to identify what parts are AI generated, and you have to disclaim authorship of those parts. I add here, it's maybe a little bit of good news for stability, because the office isn't denying registration to AI generated works because the outputs are infringing derivatives, but just that they lack human authorship. Okay, that's where the things are going. What about large language models themselves and training data? Well, the software that embodies the large language models are almost certainly eligible for copyright protection, but it's a really interesting question for people like me anyway, whether the large language model itself is within the scope of protection that copyright law applies to, or that copyright provides to the software. So in general, mathematical representations, statistical creations are not eligible for copyright protection. They're excluded from the scope, but the same problem may happen as to the large language models as the outputs, which is they're the product of automated processes, not of sort of the kind of intellectual creation that copyright law was kind of thinking that that's what we're about. So what about training data? Insofar as there's kind of curation and some selection and arrangement of material for the training data, that's possible that there could be some claim of copyright. But just cleaning up the data is probably not enough. But one of the things that I've been hearing from people who are working in this particular space is that a lot of people are just slapping licenses on collections of data, whether they're copyrightable or not. Data as such is not within the scope of protection that copyright law provides to works. So these are some of the other unanswered questions that are out there in terms of generative AI. So in conclusion, it's going to be years before courts are able to find a definitive answer to questions that I'm addressing here. Global conversations about AI governance are going on in capitals around the world. A lot of the questions have to do with is special legislation specific to AI need to be adopted? The European Union is planning to finalize what they call their AI Act, which will impose heavy responsibilities on AI developers and on companies that deploy those AI systems based on levels of risk posed by the deployment. The AI Act was actually developed with kind of specific types of AI systems in mind, right? So an AI system that might be used in the healthcare system, an AI that would be used to kind of help with managing important infrastructure, right? So electricity and the like. And then along comes general purpose AI, and they don't know what to do with it. So that's a kind of unanswered question right now. And generative AI is kind of throwing another wrench in the middle. So the US doesn't really have much in the way of special regulations now. There's a framework for risk management of AI systems that NIST has published, and there is also an AI Bill of Rights, but that's actually just a set of principles operating at a really high level of generality, and not anything even close to being a regulation. So the odd thing is that copyright law is the only law that's already in existence that could bring generative AI systems to their knees. Okay? Court says ingesting, infringement, the whole thing basically can be destroyed, right? So the copyright law could, it's an existential threat to progress in this particular field. Now, I don't think it's going to happen necessarily, but I just wanted you to know that this is out there on the horizon, and it's worth being attentive to it and trying to build arguments. If you think that it should continue to thrive, help to build arguments that it will actually advance the purposes of copyright rather than destroy it. But I can tell you that there are a lot of mad people out there right now in the copyright land about generative AI. So that's it. Okay? Thank you.
Wow. Okay. So you said something. I was shocked to learn what you said that about the Copyright Office not covering anything that's generated with AI, because now I'm thinking about any film that's made with computer graphics they use a lot of tools, and some of those are on the fine line between what's AI, but how does that work? Because if they're partly, and even these generative they're steered to a large degree by selection, at least by the human owner. So how have they addressed those kind of nuances?
Well, this is an issue that the office is going to have to visit and revisit and revisit, right? It's done, they've published one policy statement about it. They haven't been thinking about the implications for Disney, for example. And Disney's going to kind of keep a low profile on this one because they don't want to get to say, oh, well, this was computer generated, therefore it's not protectable within the movie, so anybody can take it and use it someplace else. So that's actually a serious thing that they have not thought about. But I know the people in the office who are working on it, they're trying to do their best, but it's one of those areas where they don't have inside technologists. I've been arguing for years that the Copyright Office ought to have not only a chief technology officer and a little office of those people, but also a chief economist who could basically do some essentially economic analysis, because the Copyright Office right now, right, it started, copyright law used to be this like little thing over here that hardly anybody paid attention to. And then software came along, and they decided to use copyright for software. And ever since then, it's just been one scramble after another. And the office is more or less setting industrial policy of the United States through some of their decisions. And they don't have any expertise on this at all. It's really scary.
Wow. Okay, so I should open up for other questions, and I'm sure we have a lot. Well, thank you for ending early, because we have a good amount of time for extra questions. Bob, I'll give it to you.
As you said, you have to somehow connect the expression in a derivative work, in a generated work, with the inputs to show where it was taken. And if I say, please make me a picture of the Mona Lisa playing basketball in the style of Pixar, I mean, there's both a textual input and a graphical input to that. So how do I disentangle the impact of the text prompt from the data prompt caused by the scanned pictures. Those are very different kinds of expressions that are being.
Yeah, I mean, one thing actually is that until really the last year or so, this kind of copyright and AI-generated stuff was just a toy problem, right? Lots of people have been thinking about it because it's kind of interesting, at least if you're people like me. But it wasn't real, as in it didn't really have much in the consequences in the real world. So I think one of the things that Castanova is trying to do is to say, I didn't just punch a button and have this thing show up. I went through a series of prompts, and so I was actually feeding the large language model, the ChatGPT, with so many ideas about what I wanted the thing to create that I, in fact, have some authorship to it. And the office said no. Now, again, Castanova will keep trying, but this may end up in the courts too, because to the extent I mean, the metaphor that Microsoft and GitHub have for Copilot is actually a really good metaphor, I think, generally, which is if you think about the AI systems and what gets generated as a kind of collaboration where the AI is your co-pilot in the creation process, it seems to me that that might be something that would support copyright in these things. And I think that's the direction that Europe is going too.
Hi, this is like somewhat tangential, but the web crawling case made me think about this. You mentioned how a recent case talked about how web crawling could be allowed under copyright, but I think that's if we assume that it's public data that's being indexed. Could the argument be made that some of these images for the Stability AI case is actually private? And if so, then that follows a whole new set of rules.
Well, one thing that would happen, right, if somebody essentially busted into a database of, let's say, valuable images, right, kind of broke through the paywall, that would be a factor that would cut against fair use. So, but let me just remind you that the Authors Guild v. Google case involved copying from millions of books in research library collections. And that was a private collection, but Google just scanned the millions of books to make the Google Books corpus, and that's one of the reasons that the search engine is so good, is because it's got a lot of data to work on, and a lot of the research library books have a lot of knowledge that people might actually want to ask questions through a search engine, and so that's one of the reasons why it's been better than Bing, is it has more data.
Is the human generation standard that the courts are using now something that is codified at the law level? I mean, it sort of makes sense because that's historically, it was always the human generation standard because we didn't have anything else. But is it just being used as a cop-out because when it's not human, then it can be done at scale, and all of a sudden, then the Copyright Office can't handle, 100x more requests?
Well, the copyright statute itself is more than 300 pages long. So it's a really thick thing, but it doesn't have, for the kinds of things that you'd actually want to know the answer to, it has very bare bones rules. So that the part that sets forth the exclusive rights is probably about 25 words long. It's really short. So it's, how far does the derivative work right extend? What exactly is a reproduction that counts as infringement? Those are all left to the courts.
But the human itself is an ad hoc statement that they just sort of created in response to this one specific case. It doesn't exist anywhere in the...
Well, you know, one of the things that lawyers do is kind of build upon existing precedent. So we always start, right? And the part of the problem is, of course, is that you know, what's happened in the past isn't always a reliable guide to what's going to happen in the future.
Okay, you're next. Everyone, put your hand up if you have a question. I see a lot of questions here. So we're going to try and move quickly through as many as we can. But you're up next.
Test. I don't know if this is on. Okay, I'll just say it. So my question is similar to the co-pilot question. A lot of people I know are using these tools with work. So they do internal work. There's not a copyright issue. What if they did something that write copy for an ad or something like that? It's fair to say they're at risk because there hasn't been a decision as to whether they legally own the content. That's kind of a question statement.
One of the things actually to realize is that copyright is a strict liability regime. You don't have to intend, you don't have to know that something's copyrightable. So if the outputs are infringing derivative works, and you were the person who generated that, you are as liable for copyright infringement as the person who developed the software that generated it. Okay, so and that doesn't matter whether it's you're just using it, you know, as little art in your basement, or whether you're using it as an ad. I mean, if you use it as ad, that might mean that there's damages that can be paid for, or the damages that can be awarded. But again, it's really important to understand that the copyright really extends to, right, if I create with something with this tool and that tool, no, that output is infringing, it means I'm an infringer, not just OpenAI.
Yeah, thank you. Great discussion. First of all, I don't know why the Copyright Office doesn't ask AI what it thinks and how it should the copyright apply to it. Secondly, there is an issue here, like in case of AI utilizing open source community of developers to generate code, which means that they now generating income. The company, aka Microsoft, is generating income from an AI trained on my code.
Yes.
Which means that I no longer can get the job and generate income. So what is the solution there? I mean, there is one thing to create knowledge for general public, so when I ask question, I get the response. In the case of copying all the books and putting it in the search engine. But there is another element that the company, Google, and now in AI world, Microsoft is generating income, and I'm left out. So what is the solution here in terms of...
Well, so it's important. Thank you for asking that question. The GitHub case about Copilot is a class action lawsuit brought by 4 programmers who as yet are unnamed. They're Doe 1, 2, 3, and 4, and they object to the use of the open source code in the GitHub repository as essentially training data for Codex, the large language model that then Copilot is an application for. And they basically say, you know, I put this up under this license, and the license actually requires some attribution, and now you're making money off this, and that isn't fair. And again, there's a claim in the case. I just talked about copyright because even copyright's like really hard. But one of the things that's going to be I think a question in that case is that Copilot doesn't write whole programs, as I understand it. It suggests code, and so it could be like snippets in the Google Books case that I talked about before. I mean, that's at least possible.
But it will evolve to the point that...
Yes, I mean, that's why there's a lawsuit, is that there are people like you who think that this isn't fair.
So with tags, you can basically say, please don't index me or things like that. So that's kind of an excuse, kind of a safety mechanism, right? And then the other thing is, like for instance, if you type in linear fractals, I'm number 1, they quote me, and they have all this stuff, and I think it's really great. So can I give authorization to Google to say, please spider me more often or something. I mean, so
I don't think so.
I mean, that's what should be put in the structure of things, because I think that would optimize what goes on in being able to index information.
Okay.
Oh, okay. So I'm wondering what your understanding of how lawmakers today understand these issues. Do you think they're going
I'm
to make?
sorry.
I was wondering what your understanding of how lawmakers today understand these issues.
Yeah.
If you think they understand it well, and if you think they're going to make like decisions that are consistent with what you feel.
Well, again, just on the copyright issues, I think it's a pretty good fair use case for ingesting data that's on the open internet. I think that's probably okay. And to the extent that there's outputs that are not substantially similar, I think that's likely. And one of the complaints, the stability, the Anderson versus stability case, basically says that the outputs are unlikely to be substantially similar. It's like, from the standpoint of the stability lawyers, it's basically you're admitting that they're not infringing derivatives. Now, one of the things that's going to happen is that there's going to be an effort to kind of stretch that concept of derivative work. If you remember that last phrase, or any other form in which the work is recast, transformed, or adapted, you can imagine a court giving a broad interpretation to that, even though most of the cases give it a pretty narrow interpretation. So, it's a non-trivial argument.
Thanks for your talk. So I just want to build off on the question on like licenses, right? So I was wondering if your training data all have different licenses, and now potentially, those licenses may conflict with each other, or they may have issues with each other. So how does that kind of affect the AI model at the end? And
Yeah, there are license claims in the Getty Images case. They're saying that it was a breach of the license that Getty Images has for access to the images in on their site, and so that will definitely get litigated. As I was just saying, with respect to Copilot, there are kind of license breach issues in that case also. But exactly what licenses do and how much they're enforceable is a question that people can debate about. And I've been talking to people who are saying, hey, I have this one pot of data over here, and I got it under this license, and I got another pot of data over there under a different license, and the licenses aren't the same. Can I combine the data? And what people are having to do is just decide how much risk to manage. But for example, if you just have a compilation of data and there's no creativity in the selection and arrangement of it, then it's not copyrightable at all. And what Creative Commons does is it basically says, hey, I created this work of authorship, and I could get thick copyright on it, but I'm going to put it under a Creative Commons license instead. But the license sticks to the work because it's a license to use the copyright. And so if there's no copyright in the data collection, there's arguably no basis for imposing a license.
Okay, we have time for one last question, and I know many of you have questions, so also good fortune that Professor Samuelson is here on campus. She'll probably stick around for a little bit to take some questions, but she's also on campus, so you can find her or take her classes. Question? Go ahead.
So I had a question that I've been thinking about for like about a year now since DALL-E came out, is there's a ton of legal questions that are still open about these generative AI models. But what about the ethicality of it? Like every time I use ChatGPT or Perplexity or Midjourney or whatever, is it inherently unethical because of the way data is ingested? Is that something I just should wait on?
Yeah, again, whose ethics are we talking about, right? There isn't like a general consensus about this, but some of the people who object to the ingestion basically say it's just unethical. So people, who are sympathetic to the idea that the ingestion of, billions of things is just unethical because you didn't ask permission, then don't use it. But I would say that, most of the people who are using it are not thinking about the ethics issues at all. At this point, there's no law to enforce a particular ethical norm on this thing unless there's copyright infringement.
So I really appreciate that last question because it really hints at the broader scope. I mean, what you've told us today is really interesting and alarming. Actually, things that really surprised me, and to some degree, how much the whole AI industry is at risk for if this goes the other way. And in these cases, I think there's also a big question about you didn't touch on patent rights, which is another whole issue about who owns the patents that are being used and the underlying technologies for these things, which is another whole lecture, I think. But I want to say it's so wonderful to know that we have really, this is such an important question, and it really is at the heart of what Berkeley does. And in thinking about the public interest and about open source, that's so much part of our primary values. And we have someone who is really carrying the flag on this issue. She's done it since she began with, I think, it's one of those things where she started with a hunch. It was a little tiny corner of the field. It's now grown to become so central. And so you're hearing from the world authority on this matter today, and I am so appreciative. Now, before we give her a big round of applause, I want to say that last question sort of brings to mind that we have many other lectures to go on this topic. We need to hear from philosophy, we need to hear from history, we need to hear from literature, we need to hear from art, so many different subfields. So there's a lot more to come. I want to thank the Citrus organization, all the key people there, Kostas, Camille, Lori, Cheryl, Daisy, Andre, who's behind the scenes making sure all the AV goes well all these weeks, and Angie Abaketola, who's right here, who's been the partner from the Bear Research Lab. So thank you for all of you, all the organization you've done, and a huge thanks to you for all the work you continue to do.